Morning, everybody. We're just waiting for people to drop in, so I won't launch into the sort of welcome and introduction yet, as I can see people trickling into the room, as it were, but nice of you all to join us. I think we're pretty much getting there now with everybody joining. So I will start my gentle introduction just to say hello and welcome. This is another of our Employment Today webinars. I'm sure most of you joining know us. I'm Kerrie Hunt, Head of Employment at Thrings, and joined by Natalie Ward and Carey, Willis, Fleming. We're hoping to bring you a little bit of food for thought today. Those of you who normally join us at our webinars in the office or our seminars in the office will know that we tend to do this over coffee and breakfast, and sadly we can't do that at the moment, but I'm sure you're all sitting comfortably with your own mugs of tea and coffee and maybe the odd pastry or two. Some little bit of housekeeping just to let you know that we'll record the session today, so anybody that has to drop out or misses something, you should be able to catch up with anything that you miss, and we'll circulate that after the webinar. Equally, none of your details will be visible, so it will only be us that anyone will see. Another bit of housekeeping, we're probably going to run a poll at some point just to try and get a few of your thoughts back, reflected back to us. So we'll let you know when that's happening, and again, that will be on an anonymous basis, so please do join in with the poll. Those of you who've been to Zoom webinars before, whether that's ours or lots of others, there are a lot out there at the moment. I'm sure you know that there's a Q&A function, so if you search on your laptop or iPad or however you're joining us, then just click on the Q&A, and if you've got any questions as we're going through, then post them there and we will try and pick those up at the end. So you'll know from the invite that the three of us are going to cover 3 different topics today. I'm going to give the inevitable sort of COVID catch-up bit. There are still things we need to talk about, so it's probably just a light touch on where we are at the moment with all of the various things happening because of the current pandemic. Natalie is then going to talk about what we're possibly seeing as developments in discrimination in certain sort of interesting areas, so looking at whether this is possibly a future trends section, and then Carey is going to do a case roundup. So without much further ado, I think everybody is probably with us now and has trickled in from the waiting room. I will crack on and talk about the first section. And as I said, a little bit of a sort of COVID update, where are we? And I'm just going to talk briefly about the various schemes, where we are with those, and also workplaces and working from home. Topics that we've maybe touched on before in the past, but I think it's worth a bit of a roundup at the moment. So COVID schemes, I'm sure you all know, particularly those of you who have been and are using it, the coronavirus job retention scheme is coming to an end at the end of this month. So at the end of October, the job retention scheme comes to an end in its current form. Therefore, not a lot to say about that really. I think the only thing I did want to say about it is just to remind everybody that there is the possibility of an audit. We've seen some fairly sort of scary headlines and big figures on audits. HMRC floated the notion that they thought there could be anything up to, I'm just checking the figure, about £3.5 billion worth of wrong claims or false claims. Anything ranging from outright fraud, ghost companies, ghost employees, to miscalculations when you've been making your claim, and entirely understandable miscalculations really, and errors, because at the outset everybody was learning at a fast pace how to submit claims, what you could claim, etc. And then even later on, when it switched on the 1st of July to partial furlough, partial working, claims became ever more complicated. I spoke to many a client who was lying in a darkened room with a flannel on their head, trying to run payroll at that time whilst juggling everything else they were doing. So you have my sympathies on that score, but the serious point really is you should check and make sure that you can satisfy yourselves as much as possible that your claims have been correct. There was an amnesty whereby employers weren't going to suffer fines or penalties if they self-reported and thought they had miscalculated their claim. That amnesty expired on the 20th of October, so an ill-timed webinar here if you weren't aware of that. Despite that, however, I would still say that check your claims when you finally get to that final end. Make sure you're satisfied you've got everything right, and if not, then self-report in any event. You're far better to do that than wait for a letter from HMRC. As I said, a 5-year period, so clearly it is something that could happen down the line. Make sure your paperwork is together now as well. So get it ready just in case you are ever audited, really, is probably the best advice at the moment. Moving on from that then, what happens at the end of the CJRS? Well, we have the JSS, which kicks in on the 1st of November. Now, the first purpose of the JSS was to support employers and employees where there was work to do, but not full capacity. So you weren't really ready to bring everybody back full time, so short hours. In very simple terms, it's a scheme whereby employees have got to work at least a third of their hours, and then the lost hours are really borne equally by government, employer and employee. So government will make a 1/3 contribution in terms of paying for those lost hours. The employer will pay for the 2nd third of those lost hours, and the employee will actually bear the brunt of not having a third of their lost hours paid or recovered. So very simple in theory, in principle. There's been a fair bit of debate about the pros and cons of it, whether it will really be very much utilised. And the poll will ask that very question shortly. You have to bear in mind there are a couple of sort of details. You can't make people redundant or have them under notice whilst you're claiming under the JSS. There is obviously a bit of a productivity gap. You may well be paying employees for more hours than they're actually working and be productive. But although a lot of the commentary has looked at the bare minimum of employees working only a third of their hours, actually the more hours employees work, then clearly the percentage that you might have to pick up is much less. And it's probably very much worth doing that sort of analysis. Why might you want to do it? Well, you might want to avoid redundancy costs right now. You might want to retain people because you're anticipating building capacity, and you'll be able to respond more quickly if you've still got employees doing something. You might think it helps retain your talent if you don't have full capacity for them to come back and do their full-time hours. You're uncomfortable asking them to reduce quite as much as you would perhaps need them to, and actually they might be able to see that you're investing in them and you're still sharing in this pain together, and perhaps you retain some people who might otherwise look for a job that is full-time and where they can be paid full-time. So it's worth doing the analysis. I think probably it may be useful for some businesses, but there is quite a big question mark, I think, over whether people think it's going to be taken up very much. The second part of the job support scheme, the JSS, came in more recently, and again it will start on the 1st of November. It will last for 6 months, as will the first part covering the shorter hours. And this is really furlough by any other name. Currently only applies where businesses are told they must close. So what we're looking at there really is currently in tier 3. It's pubs that don't serve food. A packet of crisps and some pork scratchings will not probably suffice as a substantial meal, so they will have to close. So the job support scheme in those scenarios is going to step in, and the government will pay up to 2/3, 67% of their salary. So it is different to the current furlough scheme, but it's pretty much the same principle. Employers don't have to top up, but employers will still have to bear the cost of national insurance contributions and pension contributions. And that's the same with the first part of the JSS, the shorter hours. So there is a bit of a cost to employers, but obviously there is some support there. And we've all seen lots of fraught headlines recently where lots of people don't think that that's sufficient support, and they're trying to press that the government increase that to the 80% people have been getting under the CJRS. That doesn't look likely to happen. One development that is imminent, though, is that today we have been told we can expect to hear from Rishi Sunak, who is going to extend the JSS to help support businesses in tier 2 areas. Now, we don't know what that might mean yet. I keep touching wood, and can say that largely in the Southwest, we're in at medium level, tier 1. I know I've got people from London joining, and unfortunately for you, you're in tier 2. And it does seem likely that areas and regions and cities are going to be moving up and down that scale, mostly up that scale. So it's worth keeping an eye on what the support will be. And it does sound like we're going to get an extension for some more support for tier 2. Finally, on the sort of schemes that are available, the CJRS bonus scheme, and it's just a reminder really that it's there. So if you have furloughed staff under the CJRS, if they are still employed by the end of January, 31st of January, then you can claim a £1,000 bonus per employee. The only added detail really I can give you at the moment is that the scheme will open in terms of making claims on the 15th of February, but close on the 31st of March. So it's quite a short window really. If you are going to claim that bonus to support the business, then you've got that window to do it, and more details of how you do that should probably be coming out in January. So it's a reminder that it's there really, more financial support for businesses. So that's pretty much where we are on the schemes. And if Natalie has launched the, which I think she has launched the poll, then please do join in. There's 2 or 3 questions there, and it'll be interesting to sort of share those at the end. I will continue to rattle on. The other area I was just going to talk about a little bit was sort of COVID workplaces. And by that, I mean when you are physically back in your normal workplace and whether or not you're working from home, and just share some thoughts on that. In terms of COVID secure workplaces, we covered in a webinar much earlier how people were looking at adapting and making COVID secure their workplaces, and there's all sorts of things been happening. The one thing or detail I wanted to just mention and pick up on today were 3 or 4 letters that tend to strike fear into the hearts of most of us, and that's DPA, GDPR. So what do I mean by that? Well, we have seen, I think, over this period, as things opened up and businesses opened up and we started to go out and about, and equally some workplaces, lots of things happening, lots of temperatures being taken as you go into a premise, and you might be doing that in your own workplace. I am going to share that I was very excited to go to the theatre last night. Yes, a real live theatre with real live actors on stage in an auditorium. It was very weird. We were wearing masks and there really weren't many people in that auditorium, but as a theatre goer, it was a joy to be there. So I'm just going to say support the arts, but when you do, you probably will have a temperature check as you walk into the theatre, as we did at the restaurant we went to beforehand. So we're all getting quite used to this. Now, as an employer, the serious point, and the thing that I was actually going to talk about rather than my trip to the theatre, is that any processing of health data under GDPR and data protection law is processing of special category data. We used to call it sensitive data, now it's called special category data. So you do have to be very mindful that you are processing that type of data. If you are taking any health data, that might be temperature checks, it might be all around the testing and tracing, whether people are self-isolating, reporting symptoms, so on and so forth. So the key thing and key reminders I just wanted to really flag today is make sure that you tell staff what you're doing and why you're doing it. Make sure that you keep it to a minimum when it comes to processing and what you do with any of that data that you then retain, use, share. Make sure that you've updated privacy notices, policies, carried out risk assessments. And if you're asking yourselves, well, is it lawful to do all of these things? Bear in mind that the tests really are that you would have to show that there is a legitimate interest in processing any type of data, or that it's in order to comply with legal obligations. They might be employment obligations, health and safety obligations, or you can try and get explicit consent if you're processing health data. Explicit consent, always a tricky one, A, because it has to be freely given, and B, it can be withdrawn. So you do need to think carefully if you're processing doing any of that kind of temperature checking or processing any health data. A lot of common sense around it, but clearly data protection laws can kick in, and fines and penalties if you get things wrong can be quite high. So do also look at the Information Commission website and make sure that you're sort of up to date with what they're saying in this kind of area. Another couple of things. One about the NHS Test and Trace app, because I have been asked this question. Can you force employees to use the app? Well, no, in a word. You can encourage, and you can explain why you think it's a good idea and why it will help protect them, help protect the business, all of that. But you can't force people to use it, so do be wary. And the final point around this sort of health area that I wanted to mention, lots of different things have been covered before, but the final point was really where people are self-isolating, and whether that's because they've been contacted through the app or through the sort of test and trace call centres, or they're self-isolating because they've got symptoms, but particularly where they're maybe self-isolating because they've been contacted. Do not force people to come into work. I'm sure that you won't as responsible HR professionals, but it was just a reminder that on the 28th, it was, of September, they've actually reinforced the sort of laws behind self-isolation. So as well as individuals being fined, and if they don't self-isolate when they've been asked to self-isolate, employers who ask people to work when they should be self-isolating can also be fined anything between £1,000 and £10,000. Quite aside from the financial fine, the reputational damage clearly would probably be immense. So anyone who feels that they're being forced to work when they should be at home self-isolating, they can work from home and self-isolate, obviously, but anyone who couldn't work from home and has to self-isolate, be aware that the rules and the fines and the potential criminal prosecutions are tougher. Final word from me was really just to talk a little bit about working from home. Again, it's a topic that we've covered before, and everybody probably feels, well, yes, you know, we're doing it, we've been doing it, we kind of get it all, and I don't disagree. I think probably it's lasting a lot longer than any of us could ever have anticipated. I feel that personally. And it's clearly probably, although we were all slowly reopening and returning to offices and city centres, 23rd of September, we were suddenly told to sort of ease off again and maybe work from home if we could. So clearly we're probably in for another sort of 6 months of it, let's be honest. And a quick sort of thought around what that means from a management and HR perspective. And I think to sum it up fairly simply, I think that we talk a lot about the trust and confidence in the employment relationship. And I think what's really being tested now is whether or not you have a real framework of trust in your employment relationships between management, HR and staff. Far less of the master-servant relationship in old-fashioned employment law lexicon, and far more of a sort of adult-to-adult relationship, really. A very necessary change, some of you may think we did that anyway, but clearly with vast swathes of workforces working remotely and working from home, there's a very different sort of dynamic going on in terms of that trust. Employees have a lot more autonomy, but possibly also a lot more accountability for themselves. And I think that we've probably seen an awful lot of positives come out of that. People feel they've got more control over the day job, they're not being micromanaged perhaps, more innovation, more improvements, using their initiative, maybe more job satisfaction. So there are lots of positives in this, provided obviously there's a clear framework there and management and the business aren't worrying about productivity. There's always that tension between, are people really working hard at home or are they slacking, or actually at the opposite end of the scale, people working far too much and they're chained to their desks and their back bedrooms and their dining room tables, and actually they're at risk of suffering from burnout. So I suppose the key question that we all need to pose is, in terms of what that means for management, it probably does, particularly now we know we're genuinely likely to be in it for another 6 months, I would imagine. We need to make sure that we are reviewing management practices and HR practices and policies. So are we genuinely adapting to this change for a little bit more of the sort of medium term? It's no longer just a kind of reaction to a situation we thought was going to be short term. So how are we helping managers, supporting managers? How are we interacting with staff? And we might have got through the first 6 months, but are we fit and ready to get through the next 6 months? Because this does look as though it's going to be a bit of a longer normal. And I think on that front as well, the other sort of area of flexibility, that the last thing I kind of wanted to mention was just thinking about working hours. Because whilst the shift in office space and remote working has been a fairly obvious outcome of the pandemic, the working hours has perhaps been less apparent, but just as significant. And I think we've seen an awful lot of people who were coping with childcare, homeschooling, being forced to do Joe Wicks PT for an hour every morning, all those sorts of things that meant the working day actually was a lot more flexible than it might have been when you're used to seeing people sit in an office with a coat over the back of their chair from sort of 9 to 5. And the question really is more a question that I'm posing, is whether that's going to continue. Historically, obviously, we've had a flexible working regime. Historically, having advised on it an awful lot over the years, I would say that it was often met with resistance, and the usual excuses would be, but they can't manage remotely, they can't supervise, they can't join in with teamwork and collaborate. Lots of resistance, just a gut feeling of it just won't work. Well, as we've seen, necessity is the mother of invention. We've had to make it work, and people have made it work. And anecdotally, I think that has been as much about working from home and being in a different space as it has about working hours. So very recently, for example, I saw an employee who had been proposing now to their employer that actually they're just their working day. So they start earlier in the morning, they take time off to do the school run, they come back to their desk, they take time off to do the school run at the end of the day, and then they finish an hour and a half after that. That's the employee asking to be able to work that flexibly. And the key thing really, I suppose I'm putting out there is, have you looked at your flexible working policy? Is it still fit for purpose? Do you even need a flexible working policy? Has it become more of a default position that if managers and staff and teams get together and decide how they want to work, then as long as the work gets done, that autonomy piece, then fine, maybe flexible working is the default. So I think as much as it is about space, there's also a big conversation around hours, which is an interesting development, I think. So let's see what happens on that front. I'm going to pause there, and yes, we have the poll results, which is fantastic. Well timed, Natalie. So using the JSS, yeah, as we thought probably, and as anecdotally, maybe not as many people looking to use it as did the full-blown CJRS, but still some, so that's interesting. Claiming the bonus, yes, some people are, so that financial support obviously still quite welcome, and a majority looking to claim the bonus. Post-COVID, this is the one I'm interested in, full return to the workplace, at least a third are expecting that, but actually just over half expecting a hybrid approach, which is really interesting. So definitely that does seem to match the statistics. Our poll, possibly slightly higher than some of the statistics that I had seen, which were talking about maybe up to sort of 37% compared to, I think, about 18% pre the pandemic, who had people regularly working at home, maybe on one day a week. So that's quite a significant interest. So very interesting poll. Thank you for participating. I'm going to hand over now to Natalie for her section.
Thank you, Kerrie. I've been looking at a few cases that really have started to make us think about how discrimination is going to be stretched over time, I think. And if I could put one word to probably all of the things I'm going to talk about, it's spectrum. I think lots of these issues fall within a spectrum, and that gives rise to ambiguity and therefore case law. But the first one really is a recent case involving grief and an employee's reaction to grief. In fact, it was referred to as an adverse grief reaction. And looking at whether or not he qualified as disabled under the Equality Act. And the reason for his claim was that he lost out on a bonus. And he claimed that at the relevant time, he was suffering from grief and his performance dipped. So it's not the usual sort of thing you'd expect to look at when you do have an employee who's suffering from grief. Often you'd be thinking about absences, but actually this was performance. And his claim actually was dismissed at a preliminary hearing. He was found not to have been disabled at the relevant time. The fact was that when he was suffering his grief, he was suffering pain, anger, fatigue, loss of concentration, and he had a heavier consumption of alcohol. But actually, he then went on to be diagnosed with depression. But what he said basically was he felt that the tribunal was too focused on his depression at a later period and less focused on the effect of his grief at the point at which his performance dropped. So it went to appeal, and although his appeal was also dismissed, the judge finding that the tribunal had addressed its mind to all the right things at the right time, the judge's judgment is actually a very useful look at the sorts of things that you might want to consider should you have an employee who is suffering an adverse grief reaction. And of course, a couple of things there. We're all pretty familiar with the definition of disability under the Equality Act. That employee has to have a physical or mental impairment that has a substantial long-term adverse effect on his ability to carry out normal day-to-day activities. So we're quite used to going through that definition part by part to try and establish whether a disability has arisen. And one of the things that the judge as a result of the arguments posed in the appeal, the judge considered firstly whether the tribunal had focused too much on whether or not there was an impairment first. And I think the claimant certainly had said that, and in fact the judge echoed this, that if you focus too heavily on whether or not there is an impairment, albeit it doesn't have to be a clinically recognised condition, if you establish or you think there is no impairment, then you might not sufficiently turn your mind to the effect of that impairment. So one of the things that came out of this judgment quite strongly is that considering disabilities is an effects-based approach. So you have to consider what effect it has on the individual on a day-to-day basis. And so if you sort of discount it at an early stage by considering the impairment first, then you may not turn your mind to consider the effect. And if you establish the effects, you might then draw an inference that there is in fact an impairment. So there's no rigid rule of law, but we are quite used to thinking about, well, do we know whether that employee has an illness? Have they ever been and got a doctor's report? Whereas actually what this case suggests is that perhaps we ought to be thinking about what we see in front of us. What are the manifestations of a potential impairment on this individual, and does it affect his day-to-day abilities? So I thought that was quite an interesting point, because we're very used to running through that definition, and because impairment, physical or mental, appears first, the temptation is often to think of that first. And secondly, there was some guidance as to whether the consideration of the day-to-day effects. And in this case, the claimant argued that the decision had been wrong because they focused too much on the fact that his day-to-day activities outside of work were not particularly impacted by his grief. It was actually his activities within a professional capacity at work. In fact, the appeal tribunal found that the tribunal had addressed both, but it led the judge to go on to consider how you might look at the extent of the effect on his work, and how you calibrate that. Perhaps thinking about whether or not you would compare, say, a drop in performance to what that individual's normal level of performance is, or whether there is merit in comparing it to his colleagues. And I think really they said there is merit in both, but obviously this is about the effects on the individual, so that must take priority. It's a degree of impact on him personally, and it's the quality of his performance. So you can recognise that perhaps an illness can have an impact on his own high level of performance, but it doesn't mean to say that his performance has to have dropped to the average level across the workplace. So it's just about thinking about it on a very personal level, but still using an average as a basis for considering that. So I just thought there were a couple of interesting points in that case, and clearly, while he wasn't found to have been disabled as a result of his adverse grief reaction in this case, clearly people are thinking about it, and the judge has given some very, very careful, thoughtful, thorough guidance. So that would suggest to me that he is anticipating that there may be future claims on this subject. And in particular, we're in a situation now where over 40,000 people have died of COVID, there's likely to be a greater percentage of the workforce suffering from grief. And so it is worth bearing in mind how you might assess their grief and whether or not you consider that reasonable adjustments are necessary. Moving on then, another topic that is pretty high in the headlines at the moment is menopause, and the impact that can have and how relevant that is to working lives. And it does seem to be becoming more relevant. We have a more aging workforce for a start, so there are more women likely to be working through the menopause. And so it is becoming more important to understand it in, under the wider legal context, but in particular in relation to the Equality Act. And it can touch upon three potential protected characteristics: disability, age, and sex. I'm not going to talk really about age and sex, but it seems to be that the best route for an employee would be under the disability discrimination parts of the Equality Act. At the moment, there's no binding authority to say that going through the menopause is a disability. But I believe there is one case, probably just an employment tribunal decision, which did accept that menopause-related anemia, lack of concentration, and emotional state amounted to a disability. So I think it was all three of those symptoms together amounted to a disability. So it is out there already. But as with grief, people will suffer through the menopause in different ways. So that effects-based approach of looking at whether the definition of disability is made out becomes all the more important, and it's likely to be a very sort of complex factual consideration. A couple of those considerations again might be, is that effect substantial? What impact does it have on that employee, either in the workplace or outside of the workplace? It's going to be different for different people. Guidance can perhaps be drawn from case law that deals with impairments that have similar effects. And also the other thing for considering in relation to the menopause is does it have a long-term effect? We're used to thinking about disabilities lasting for at least 12 months. Now, the menopause is likely to last for several years, but actually the periods of time over which you suffer, or which an individual may suffer adverse effects, substantial adverse effects, may be much less than that, and it may also fluctuate. So there are different considerations there, and understanding the impact, the substantial adverse impact of those effects at a particular time when they claim that the discrimination was suffered is going to be very relevant in that consideration. And also knowledge. We're quite familiar with the principle that an employer has to have knowledge of the disability in order to be held liable for any discrimination. And that's quite tricky with menopause. There are lots of women who will not want to reveal or disclose that they're going through the menopause, or who may feel embarrassed talking about it. And equally, there will be management that feels awkward talking about it. So how will an employer know that someone is going through the menopause and therefore not treat them unfavourably? It is difficult, and I think a lot of that will come from increasing awareness within the workplace as to what those symptoms could be, in order that people are more aware of the signs, and then they can ask the relevant questions to ensure that they're putting measures in place to ensure that that anyone going through the menopause is being treated favourably. It's probably unlikely that just knowing that a woman is in that particular age category, or age bracket rather, is going to be enough to put you on notice that they are suffering from the menopause. So just a couple of considerations there, and as I said before, I think probably disability is going to be the best claim that an employee could bring, because there are the additional claims of reasonable adjustments, and also a Section 15 discrimination arising from a disability claim, and thinking about sort of analogous claims there was the Grosset approach, which was a case we covered some time ago about a teacher who showed an inappropriate film to his class of 15-year-olds. And he basically claimed that he did this as a result of an impairment that he was suffering from. It was his sort of lack of judgment was a symptom of the impairment he was suffering from. And so it didn't matter that the school didn't know. And so likewise, you can see that an employer could treat an employee unfavourably due to effects arising from the menopause, even if they don't know that that could be an effect of the menopause. So again, it's about raising awareness and training, particularly management staff, to understand what those symptoms are. And probably develop, I'm sure many of you will already have been developing a menopause policy to include things like transparent processes, guidance, understanding of the symptoms, and to allow really for a tailored response, because it's a spectrum experience for women. And to be aware also of a broad definition, in that it's not just going to be suffered by someone at a certain age. There is an age bracket, and also you get premature menopause. So linking it to age is quite a risky thing, and also linking it to sex with sort of trans issues in the headlines. There will be variations of the menopause within the workplace. And finally, on gender issues, you have probably heard there's been a recent case against Jaguar Land Rover, and so I thought I wanted to sort of touch on the gender reassignment issue, although the way that we refer to it now is just trans rather than gender reassignment. It is already protected under the Equality Act, so gender reassignment is a protected characteristic. But the view taken over the last few years is that the definition in the Equality Act is very medicalised, and it presumes medical intervention in that reassignment, and doesn't cover the sort of wider trans community, for example, people who are non-binary or gender fluid, or intersex. So there's been a feeling really that wider community isn't necessarily protected adequately. There've been quite a few surveys and reviews over recent years, and in fact the Government Equalities Office issued their response last month. It mainly focused on the gender recognition process, and simplifying that for people, and also opening healthcare resources a bit more widely for those sorts of gender issues. It didn't give any response to the issues regarding non-binary and intersex issues. But certainly there has been some guidance from the Equalities and Human Rights Commission, in that gender reassignment is personal rather than medical. And actually the view taken now is that medical intervention isn't necessary, because some people will quite happily identify as a different gender but not feel the need to go through medical intervention, and in fact some people may not be able to. So the view now is that they are still to be considered trans, even if they have no intention of going through a formal medical gender reassignment process. And the view also has been that in terms of non-binary people, the view was that the Equality Act didn't protect them unless they were transitioning to being male or female, or that they were perceived to be going through gender reassignment. So there is that discrimination based on perception, that was the only way they could be protected. But then we've had this new decision. The case was Taylor and Jaguar Land Rover. It's a very recent case. And Ms. Taylor had been employed, I think, by Jaguar Land Rover for about 20 years as an engineer, and was, I think, described herself as gender fluid, although latterly I think she usually came into work dressed in women's clothing. And she was subjected to insults, abusive jokes. She suffered difficulties with toilet facilities and with managerial support. And basically the Employment Tribunal has been pretty clear and said that gender is a spectrum, and it was beyond any doubt that she should be protected under the Equality Act. So basically, the Employment Tribunal has categorically held that gender fluid or non-binary individuals are covered by the Equality Act, although they did acknowledge that it was a novel point of law. So her claims of harassment, discrimination and victimisation, as well as constructive dismissal, were upheld. We're still awaiting written reasons when the tribunal has resources, but she was awarded a staggering £180,000 in compensation, which is huge, and that's why it hit the headlines. But I think there's no doubt that in future we're going to see that extend to different individuals across the gender spectrum, whether they are agender or genderqueer. Apparently there are 64 identifiable genders. So it's staggering, really. There's a lot to get your head around. But I think there's lots of practical steps that employers can take, an understanding of those terms, understanding all the terminology. Apparently there is a glossary of terms on Stonewall's website. Being sensitive and being guided by the individuals, and understanding what their preferences, particularly in relation to pronouns. That's quite a big issue at the moment. I think there have been quite a few cases in the news of, I think, particularly airlines not referring to pronouns in their announcements on board, for example. But it is difficult for staff to broach that subject. It's a very sensitive area. But perhaps reviewing your contracts and policies to look at how you refer to different genders and whether there is something you can do around that. Training to spread awareness of preferences will hopefully reinforce a sort of sensitive approach and an awareness amongst your workforce. It might reduce speculation and gossip, and that can be the worst thing within a workplace or anywhere really, and lead to harassment claims. And also I think it's a means of showing respect to your entire workforce and a means of fostering a more inclusive workplace. Considering gender neutral toilets is another matter. It may not be available to smaller employers, but it is something that probably should start to be considered. So yeah, that's kind of new on the horizon, but it's something that's not going to go away, and really just showing that discrimination is a very, very wide field. The scope is massive, and there's kind of no let up on new issues testing the tribunals in every sense. So on that note, I will hand over to Carey, who's going to give us a case roundup.
Thank you, Natalie. So I think Natalie's gone through quite a lot of information there about how the law might progress, and I'm actually going to go back to basics now and actually look at a load of cases that have recently come into the tribunals about the old favourite, which is unfair dismissal claims. So a little reminder, just because it's first thing and I'm the third speaker and even my neighbour's dog has been howling through, I think, so I will make sure I'm getting a whistle-stop tour through this. But as you all should be aware by now, unfair dismissal cases will arise where you have a qualifying employee who has over 2 years service and you don't have a fair reason, or in all of the circumstances, you haven't acted reasonably in treating the reason that you are giving as a sufficient reason for dismissal. So not only do you need to have a fair reason, you also need to go through a fair procedure. And it sounds really simple, but actually it's something that in practice, with all the different variants that might happen in the workplace, it's still tripping people up. Hence, this is still going on in the tribunals, despite the fact that many tribunals aren't actually managing to push the cases through quite very fast anymore. So the first case I've got here is the case of K and L. In that case, we had a teacher who was charged by the police after indecent images were found on a shared computer at their home. It couldn't be actually found whether they downloaded them or someone else did. And so the Crown Prosecution Service decided that there wasn't sufficient evidence to proceed with the prosecution, and instead reserved their right to do so later in the future should further evidence come to light. The employer didn't really know what to do. He's a teacher. So what they did was they wrote off to the Crown Prosecution Service and said, can we have the evidence that you've got so that we can use that as part of our disciplinary proceedings? The Crown Prosecution Service gave them a very redacted letter, and they nonetheless proceeded with a disciplinary, with the allegation being the teacher's involvement with the police investigation. They didn't, and this is where they tripped up somewhat, refer to potential reputational damage as a ground for dismissal. And so instead they proceeded on the basis that it was the allegation of being involved in the investigation, which the disciplinary manager didn't have enough evidence for. So unfortunately they couldn't dismiss them on that ground, and decided that the best route would be the irretrievable breakdown of trust and confidence, and the risk of reputational damage should he later be prosecuted and they continue to employ him. The tribunal rejected the claimant's unfair dismissal claim, and he appealed to the Employment Appeal Tribunal, and they actually concluded that the dismissal was unfair on two grounds. The first was, as I might have flagged, the reputational damage was not actually flagged as a potential ground of dismissal and should have been put in as a separate ground, because different considerations would have need to have been brought during the disciplinary, and they would have then been able to properly mount their defence to that allegation in itself. The second one is that, going back to basics again, where it's a misconduct dismissal, you need to actually weigh the evidence on the balance of probability. Is it more likely than not that he actually did do the allegation in question? And you can't just weigh that on the basis of, oh, well, there's a risk that they might well have done it, and there's a risk that in the future they may well be prosecuted. Again, these are all unknowns. So it's a bit of a good reminder, really, of what you need to be doing in terms of following a fair procedure, notifying all of the proper grounds, and weighing up real risks as opposed to unknown risks on the balance of probability. So that one's a good one based upon irretrievable breakdown of trust and confidence. And we've got another one. There's some other substantial reason dismissal case here, which is Gallagher and Abellio ScotRail. Now, this is an interesting one because in this one, the Employment Appeal Tribunal upheld that a tribunal's finding that dismissal for some other substantial reason could be not unfair despite having followed no procedure whatsoever. Now, that flies in the face of exactly what I've just been saying. So why in this circumstance did they manage to get away with it? Well, on this situation, there was a manager and another very senior manager. They were both senior and they'd had an absolute falling out. There was just no way of reconciling it. They had a couple of meetings. They saw whether they could actually sort it out between them, and they really couldn't. So it was decided that at this individual's appraisal, then they would be dismissed, and that would be the end of it. They just couldn't do anything further. And the tribunal looked at this and actually said, in most cases, you do need to follow a fair procedure. But in such circumstances where it would be absolutely futile to follow a procedure, then you may well be able to do that on the grounds of some other substantial reason, where there is a complete breakdown in trust and confidence and the working relationship between managers. I think in this case, it's a really rare example of this actually happening in practice. And I think it was interesting in this one that actually it came at a really critical time for the business, involving two really senior managers who needed to be able to pull together in order to keep the business running during a difficult time. And I think it was also quite interesting that they had actually already met a couple of occasions to try and sort it out, and it just wasn't working. So I think, you know, the headline, "You can dismiss without following a fair procedure," is actually a little bit misleading there, because actually I think they perhaps did have some form of procedure, albeit not necessarily the formal one. This can be contrasted again with another recent case of Evans and London Borough Council. And again, it looks like I'm picking on teachers, and I'm really not. This is just happens to be a couple of cases that are in the tribunals at the moment. In this one, we had a deputy head teacher who'd been at the school for 12 years, but the school uncovered some serious financial mismanagement. They investigated it and sent him a disciplinary investigation report of some 800 pages worth of evidence. His sister, who had been representing him, or being his companion at least, throughout the process, was unable to attend the disciplinary, and he asked for further time to allow her to attend because she was on holiday and review the 800 pages worth of evidence. But the school decided, in their wisdom, to crack on without actually having him present, and they dismissed him on the grounds of gross misconduct. He brought an unfair dismissal claim, and this was stayed because the school proceeded with High Court action to try and recover some of the financial mismanagement payments that had gone to the teacher in question and other people. And this was into the hundreds of thousands, but unfortunately they couldn't actually account for all of it, and so the High Court said that £46,000 was what the employee would have to pay back, but he didn't have the means to pay it. His employment tribunal case then gets unstayed, carries on, and the tribunal decides to strike it out, because clearly the High Court had already looked at it and said, actually, this is clearly financial mismanagement to the tune of at least £46,000. And on that basis, there was no reasonable prospects for a finding that the employer didn't have reasonable belief in the misconduct. And in any event, they said that they would have reduced his compensation to zero on the basis of either bulky or contributory fault, and that it would be not just inequitable to allow him compensation when he owes the school £46,000, which he has got no means to pay. The Employment Appeals Tribunal, however, took a different view on this, and they said that actually the tribunal should not have struck out his claim because they'd failed to acknowledge the potential value in a finding of unfair dismissal, even if there is no financial award. Which is very difficult, isn't it, to actually hear that? But I suppose their view is that there is interest in justice in making sure that all employers follow a fair procedure, even where it is inevitable that they would actually dismiss in the end. So it's quite a stark reminder, really, that you need to follow a fair process, even if you think that you've caught someone red-handed and there's no way that they could possibly justify it. Because this is inevitably involved even more costs and management time on the part of the school to actually have to defend this claim. If they had just delayed that process, allowed his sister to attend, given him a chance just to read these 800 pages, they would have avoided all of this, and they would have been successful in their strikeout application and been awarded costs probably for the fact that he'd brought it when there was no reasonable prospects of success. So an interesting case, and a quick one just to flag on the point of costs is the case of Tan and Copthorne Hotels. In this one, it was a senior vice president of a hotel group who was being told he was going to be made redundant. And he brought numerous allegations of discrimination, victimisation, harassment, whistleblowing, unlawful deduction from wages, you name it, he threw it in there, kitchen sink approach. And during the disclosure process, it turned out that he had been covertly recording hundreds and hundreds of hours of meetings and private conversations with his colleagues. And this ended up in 3,000 pages worth of documents having to be considered by the tribunal over a tribunal hearing of 7 days. The tribunal was, let's be honest, not very impressed with that. If he had been in Bristol, they would have gone absolutely bananas probably, because they like to keep their bundles as tight as possible. And they described his behaviour as deceitful and duplicitous. They also said that he should not have proceeded with his claims because he had to pay a deposit order, and he'd already been told there was not really reasonable prospects of success, and he was given an opportunity to withdraw at an early stage. And so they, the tribunal made one of the largest cost awards ever recorded of £432,000 against this employee. So that was quite a positive one to end on, really. If you do have employees who are likely to do the kitchen sink approach when they've got no reasonable prospects, then that's a good house, £432,000. So just a positive note to end on, not for the employee, of course, but there you go. So that's the end of my talk.
Thanks, Kerrie. Thanks, Natalie. We've got 5 minutes or so, and there are a few questions. So I will quickly try to run through these. One question about the JSS was asking whether it's possible for employers to top up the JSS, as was possible with the CJRS. Obviously, they're talking about the new JSS where businesses are legally required to close. Certainly employers aren't obliged to top up, other, as I said, than pay national insurance contributions and pension contributions. Thus far, in terms of the guidance, I haven't seen that topping up is prohibited. Something at the back of my mind is saying to me that I did see something about top up not being possible here to try and avoid sort of fraudulent claims, but without being able to go and check the Treasury direction and things like that, which are the real sort of key to this. I think at the moment there's nothing generally in the guidance on gov.uk that says you can't, but I would revert to the Treasury direction just to check that to be sure. Another question that has come up is around, again, the JSS, and asking about how it relates to annual leave, people accruing holidays on full or reduced hours and things like that. Now, obviously, this is talking about the other type of JSS where employees are working shorter hours, they've got those lost hours, and those lost hours are being borne equally between government, employer and employee. I think that given that you're still working on the basis that this is an employee who normally works full-time or whatever their normal working hours are, and so you're measuring how much of that are they working proportionately, and the balance, it's got to be at least a third, and the balance then is being paid for in these other ways or borne in these other ways, then you're working on the basis, I would suggest, that their contractual hours are still what you're looking at in terms of how they're accruing holiday and so on. So, because that's what the top up is for, if you see what I mean, the lost hours. So their whole hours are still really their normal working hours. The question also went on to say, what if they might have reduced in September, October? I'm not quite sure what the significance of that is. So it's starting to get a little bit more detailed, and I probably want to ask more questions than to properly understand the question. But again, if you've got somebody perhaps who doesn't have normal working hours, I don't know whether that's the issue, or they've actually agreed contractually to vary their hours, and that is now a binding contract variation, that might be what they're talking about in the question, then you would be working on those new contractually varied hours, perhaps, assuming that that hadn't been a sort of temporary variation that they were expecting to go back up or the like, so that they were still working against their notional hours. So I hope that's answering the question. Sometimes it's a lot easier when we're all in a room and we can kind of talk about it, and I can ask a few more questions. But that's a couple on the JSS, and there's another one here I'll just try and fit in, which was asking about returning to workplaces, actually, and where a manager might want staff to come in at least one day a week to do certain work that they say can't be done at home, staff reluctant to do so, concerned about the safety of the workplace. I think really I have to say, just tread very carefully here. The risk here is the risk of potential claims that people have suffered a detriment because of raising a health and safety concern, and or because they've made a protected disclosure in the sense of whistleblowing. So those are very real issues that you need to be wary of. At best, you need to try and manage the situation to persuade, encourage, demonstrate that you've complied with all guidance, that the workplace is safe. You probably also, though, have to test the manager to say, OK, let's really look at whether or not this work can be done from home. Forcing reluctant people back in, it's going to crop up here and there. Hopefully, ultimately, you manage to persuade and get people back into the workplace, because you do have to be very careful. There are live risks of claims here. So again, it's one where I would really want to examine the detail before I said, well, OK, you've done everything possible, they're refusing, now you can discipline them, because that way potentially risk does lie. I'm not saying that you couldn't do that at some point, but it's really one to be very careful about in those circumstances. I think that's it for questions at the moment. So rather than keep you all here, we will let you all go. And hopefully that's been helpful. A reminder, we always used to say that we were more than happy to cover topics and areas that you might like a refresher on, or just questions that you've got, and send them in. As I said earlier, given that we think we're in for a longer haul, probably on being remote, then we'll try and carry on doing some more regular webinars over the next 6 months. Bite-sized updates, bit of business as usual, and new things arising. So do send questions in. I'm sure most of you know our email addresses, or you can find us on the website, and you'll get another email out, hopefully circulating the recording. And again, if you need to get in touch, then please do. But thank you all for turning up, and have a good day, everybody. And thanks for joining us.